Welcome to our company law class once again. This morning, we would like to discuss the constitution of the company. We have touched on it briefly when we were discussing the mechanics of incorporation or what needs to be done in order to have the corporate form, in order to have the certificate of incorporation issued to you. So this morning, we would like to explore, analyze, and reflect on sessions 23, 24, 25, right up to session 32, dealing with the constitution of the company. And the constitution of the company is very important. First, what is it? The constitution of the company is a document which governs the company. So it's a governing instrument of the company. And on this aspect of company law, we try to transfer some of the things that we have learned under constitutional law to become part of what we are learning, in a sense. Because like the same reasoning applies, mutatis mutandis, or the necessary modification to company law. So that is the point we are trying to make. So whatever we understand a constitution to be, the same thing with necessary modifications applies to the company. So the constitution will contain provisions relating to the company's business, the company's subjects, the organizational structure of the company, the powers of the various organs of the company, procedures to follow for various matters. If it is necessary to make changes to the constitution or any of the structural arrangement of the company, the procedure to follow is also provided for in the Constitution. The capital structure of the company are all provided for in the Constitution. So those are the matters we want to explore this morning. But before we proceed, it is pertinent to appreciate that unlike the Repealed Companies Act 1963 at 179, there have been important changes to the constitution of the company under the current dispensation, the current law, which is Companies Act 2019 Act 992. But just before we proceed, we need to remember that we used to have some other nomenclature, some other description of what we call constitution now. In the beginning, going back to the historical development of English company law, which by extension is also our company law. The constitutional document of the company used to be in two forms. What we call the Memorandum of Association and the Articles of Association. It is important that we are reminded of this because as we read some of the old cases, we'll be coming across this expression. That is why, despite the fact that it's no longer the law, we still need to be aware so that when we meet it in the cases, we will not get lost as to what they are talking about or as to what is being discussed. So that is the wisdom behind reminding you of some of these old things. So previously, we used to have the memorandum of association, and the memorandum of association was supposed to address the major governance issues regarding the company. And that was supposed to be for the consumption of outsiders as well, what they should know about the company. And then the articles of association was supposed to be a more detailed regulation concerning how things are done in the company. And in the past, the content of the articles of association was not so much supposed to be the concern of outsiders, as it were. And it was against the backdrop of that we have the case called the Tech One case. When we come to discuss corporate transactions and contracts, we'll be discussing what is known as an indoor management rule. There used to be a rule that outsiders, that is those who are not part of the company, are not considered to know the inner workings of the company. And the inner workings of the company was usually premised upon the articles of association. Of course, exceptions were recognized on basis of which those who are outside of the company could, for example, be deemed to have been aware as an exception to the general rule that outsiders are not aware of the inner workings of the company. Now, when we came to have our very first company legislation, after independence, we used to call the Companies Code, 1963 at 179, later rechristened as the Companies Act, 1963 at 179, following the work of the Statute Law Revision Commissioner, VCRAC CRAP, with the publication of the Laws of Ghana in 2004 compendium. Now at 179, we avoided the dual constitutional document, the Memorandum of Association and Articles of Association, and rather embraced a single constitutional document, which we call the regulations. So if you look at the old law, you notice that the language which was used to refer to the Constitution is regulations. Regulations. So that was the language which was used to refer to the Constitution of the company. But under our current law, Companies Act 2019 Act 992, we have changed the language from regulation to, simply put, constitution. Because, well, maybe the wisdom lies in the fact that even going back to when we used to have the dual documents, Memorandum of Association and Articles of Association, as under the old Companies Ordinance of 1907, what it was doing was to serve as a constitution. Again, when we came to have regulations as the preferred terminology or nomenclature under the Act 179, which is repealed, what the regulation was doing was actually to serve as a constitution. So if it is to serve as a constitution, why not just use the word constitution? And I think that probably explains why we have made a switch to constitution, so talk about the constitution of the company. So let's look at that. And now we have what we call registered constitution and default constitution. So it's important we appreciate that. Previously, when you are going to register your company, you needed to have your regulation. So if you look at section 16 of the repealed at 179, it talks about constitution, and section 16.1, for example, the old law used to say that, quote, this section applies to a company registered after commencement of this act, that is Act 179, the repealed law, and to an existing company which pursuant to section 19 adopts regulations in lieu of its memoranda and articles of what? Association. So, by effect of section 16.1, you are being told two things. First, that the old system used to be to have the memoranda and articles of association. But then, if a company was registered after the coming into force of Act 179 in 1963, that company will not have to use the old system. It will have to embrace the new system regulation. And it was supposed to have a regulation as spelled out under section 16 of Act 179. But now, if you look at section 23 of our Act 992, you notice that the sectional heading of section 23 is that option to have a registered constitution. Option to have a registered constitution. And what does that mean? So that is telling us that having a registered constitution is not mandatory. So the law has provided what we call a default constitution. If you decide not to choose your own constitution, there are certain matters which have been provided to serve as a constitution for you, as it were. So let us take section 23. Somebody should read section 23, 1 and 2 for us. Okay, Justice Kutu.
Yes, my lord.
Yes.
Good morning, sir.
Good morning.
Okay. Section 23, 1 and 2. A company has the option to have a registered constitution. 1. 2. Where a company opts to have a registered constitution, the document that represents the constitution shall be A. Signed by one or more subscribers or the company secretary, and B. Delivered to the registrar by the subscriber or an authorized representative before incorporation, or C. Delivered to the registrar by the company secretary, director, or an authorized representative after incorporation.
Good. So you notice that by the wording of section 23 itself, is not mandatory for a company to have a registered constitution. But then if it chooses to have one, then we are being told how it should be validated. The fact that one or more of the subscribers should actually sign it, and then the company secretary, and it will be submitted to the register of companies in one of two scenarios, either before the incorporation, or you can register without having the constitution, and having registered, having incorporated, you decide to have a constitution. And that is why section 23.2 talks about the two scenarios in B and C. No, let me show that this in the B and C. So if you look at the 23, no, B, for example, where a company opts to have a registered constitution, the document that represents shall be B, delivered to the registrar by the subscriber or an authorized representative before incorporation. So before incorporation, with my emphasis, before incorporation. And then C, delivered to the registrar by the company secretary, director, or notary after incorporation. So what this means is that in terms of registered constitution, it's not mandatory for you to have one before you register or you incorporate the company. You can choose to have one after the incorporation. And again, if you don't have a registered constitution, it means you've not exercised the option to have one, then the law will give you a default one. The law will give you a default one, so we should keep that in mind. But before we will discuss, the content and then the effect, I want us to jump to section 27. Section 27, and look at the form of the Constitution, section 27. So, section 27, I thought the reader will read. Tout está ahí there. Yes, Justice, read for us.
Okay. Yes, my lord.
27.
My lord. Yes, my lord. My line cut. So the
Okay,
section
I
again.
read section 27.
27. Yes, my lord. Section 27. An unlimited company may have a registered constitution, and the form of the constitution shall be in accordance with the form set out in the second schedule, if private company are limited by shares, or third schedule, if a public company are limited by shares, or as near to those with the necessary modifications, but with a statement that the liability of the members is unlimited. Subsection 2.
Okay, so just before you move on to the 2, you notice that the 27.1 is addressing specifically a particular type of company, a company which is not limited by shares, as it were, be it a private or be it a public. And if you go to the schedule, so if you go to the schedule is at the end of the Act 992. So the second schedule gives you a default, right? It gives you, if you like, a default constitution. And then the third schedule gives the same thing in respect of public company unlimited by shares. Now let's look at the 2.
Yes, my lord. The registered constitution of a company may adopt any of the provisions of the appropriate schedule and subject to subsection 3, insofar as the constitution does not exclude or modify those provisions, they shall, so far as applicable, be part of the registered constitution of the company.
Okay, good. So the schedule has provided, some kind of like a standard provisions, which will be in a constitution for various types of companies. So we are being told that you have the option to have a constitution tailored along the same line, or to make certain changes as appropriate to you. So let's look at the 27.3, and then we will later on jump to go and look at the schedule.
Yes, my lord. The registered constitution of every company shall contain the matters set out in A, subsection 1 of section 26, and B, paragraphs I, 3 and 12 of the second schedule in the case of a private company, II, 1 and 2 of the third schedule in the case of a public company, and III 1, 4, 5, 6, and 7 of the fourth schedule in the case of a company limited by guarantee.
Okay, good. So we are being told what should be the content of a constitution. The specifics are provided in section 27, which we'll be discussing pretty soon. In other words, what we should see provided in the company's constitution. But in addition to that, there are certain unique provisions appropriate to certain types of companies, and they are contained in the default constitution in the schedules. And we are being told that the company, if it decides to craft its own constitution, will need to also include these specific matters. So I would like us to um, take note of section 28, and then we jump and go and look at the schedules, the subscription. Yeah, 28.
28. The constitution of a company shall be signed by one or more subscribers in the presence of a witness who shall attest to the signing.
Good. So very soon we'll be discussing the effect of a constitution when registered and so on. And it is important that the constitution is properly adopted. And that is why section 28 is saying that the document to be treated as the constitution of the company should be signed by at least one or more subscribers, those who are working to bring about the company into being. Or if the company has even been, incorporated already, then the company secretary, as we saw in terms of section 23 2C, so that there'll be no doubt as to whether the document was properly adopted or somebody is just trying to smuggle it in and let it appear that that is the constitution of the company. So I want us to quickly run our eyes through the schedules. So we are traveling to the schedules now. Let's go and look. The first schedule is the interpretation, but the second schedule are the constitutions. Yeah, so as you notice, the schedule start from here, see? And so if you notice, the first schedule is the definition sessions or the interpretation session. So that's not what we're interested in. We're interested in the second schedule, so let's keep moving. Good. So this is what we'll be discussing. The second schedule. You know that it makes reference back to section 24, 25, 27, and 301. Constitution for a private company limited by what? By shares. So if it's a private company limited by shares, this is the default constitution. Default in the sense that the provisions contained here will be deemed as the governing provisions of your constitution. If you're a private company limited by shares and you opted not to have a registered constitution of your own, if you opted to have a registered constitution of your own, you will be allowed to make modifications to suit whatever you wanted, so long as it's not in violation of mandatory provisions of the law. But if you don't opt for your own, then if you're private company limited by share, the presumption is that you have this. So this is your default constitution, as we can see. So this is your default constitution as a private company limited by share. So as you can notice, we have about 46 provisions. I think more than that, I think about um, so all these are part of the constitution for the private company limited by shares. That's about 70 something, 76
76.
provisions. Yes,
Okay.
76 provisions. So all these are the provisions of a company, provision of a constitution for a company limited by share, private company, if you choose not to have your own constitution. But if you look at the section 76, not section 77 of Act 17 of Act 992, but section 76 of the second schedule, which is the default constitution for private company limited by shares. The interpretation section therein says that uh, in this constitution, unless the contract otherwise requires, a private company may, in a constitution registered by the private company, exclude or modify any of the provisions of this schedule to the extent permitted by this act. So you can have your own constitution as private company limited by shares, and you can make changes to all these 76 or 75 provisions, so long as the law does not prohibit it or the law does not prevent you. But if you choose not to have your own, in which case you have made modifications, then as far as the law is concerned, you are deemed to be relying on the second schedule as a constitution for your private company limited by shares. So let's keep that in mind. Then we also have the third schedule. The third schedule. The third schedule is a constitution for public company limited by shares. That's the default constitution too. So let's run our eyes quickly through that and also see that one. On your own, you must read through the schedules and have a general idea of what they look like. Because of time, we cannot read all the schedules. Good. So let's go to. You notice that it's also made up of 78 provisions. The private companies limited by shares constitution is made up of 76 provisions, as we saw. And then the public company limited by shares constitution is also made up of 78 provisions. Then we also have the fourth schedule, which is the constitution of a company limited by guarantee. So that one, you notice it's just 40 provisions, as it were. So these are the default provisions or the default constitution. If you are a company and you decide not to have your own registered constitution as permitted by section 23. Good. So now that we have looked at the form and subscription of companies, there's one thing I would like us to touch on before we begin to discuss the effects. Now, there's a case which came up in our court, the case of uh, the Paul Wood treatment against Asari. And I'd like all of you to read that case. 2005, 2006, Supreme Court of Ghana Law Report 687. So the Paul Wood treatment against Asari. And the effect of subscription in terms of what we have discussed under, I think, section 28 came up, which was about the subscription. Yeah, section 28, the subscription. And leadership Sophia Akufo made a statement regarding the effect of subscription to regulation. It was in reference to at 179, but because the provision is in pari materia, that is in material the same terms as the current one, the jurisprudence around the repealed one is very much useful in eliminating the current provisions. So in the Paul Wood treatment against Asari, Sophia Kufu JSA, she then was stated, quote, furthermore, by virtue of section 30 of the code, subscribing to the regulations of a company confers a special legal status on the subscriber, making him or her a member of the company from the moment of its incorporation, unquote. So later on, we'll be discussing membership of a company, and we'll notice that if you are a subscriber to the constitution of the company, by virtue of being a subscriber, that makes you a member of the company as it were. But there was a very important issue which came up in the case of Adesheman Gardens Limited against Asibe. Adesheman Gardens Limited against Asibe. And that, in that case, is 2003, 2004, 2 Supreme Court of Ghana Law Report, page 1016. Adesheman Gardens against Asibe is a case I'd like all of you to read, especially for those in Kumasi. There used to be a place called Adesheman Gardens. So the case is about that place. And the issue is your membership dependent only upon whether you are a fully paid member of the company, or if the company says that you are a subscriber. By being a subscriber, that is enough for you to be treated as a member of the company, regardless of the fact that you have not fully paid for the shares which have been issued to you. So I'd like you to read that, because in Adesheman Gardens, we have a company which was incorporated in 1991, and it was registered with about 1 million shares of no par value. The regulation of the company shows that the subscribers to the company were the second appellant, who subscribed to 600,000 shares, for which consideration payable in cash was 600,000 old Ghana cedis. And also, one Nana Osefriye and the respondent, they each had 200,000 shares, and they also supposed to pay for that in cash, 200,000 cedis, Ghana cedi. Now, sometime after commencement of the operations of this company at the Shemine Gardens, there were problems between the second appellant and the respondent. Now, the respondent claimed that he was a fully paid up member of the company. And for that matter, was fully paid up member of the company, and for that matter was entitled to take part in the day-to-day running of the company. The lawyers of the company informed the respondent that the respondent was only a nominal shareholder of the company. That is to say that a shareholder in name. Why? Why did they say that? In their view, he had not fully paid up for the shares which had been issued to him, so he was just a nominal shareholder. And the letter the lawyers wrote also purported to offer to the respondent 20% shares in the company, in consideration of which he must pay an unspecified sum of money that he was to ascertain by contacting the office of the managing director within 14 days, failing which the shares will be offered to someone else. Now, this letter was immediately followed by another communication from the second appellant, in which he referred to the solicitor's letter and informed the respondent that as a nominal shareholder, he had not paid for his shares. In order to become a fully fledged shareholder, he must pay a stated amount, being 20% of the current net of the company's assets. So this certainly resulted in litigation, which came before the court in this case. And the question which the court needed to answer, or the issue to be determined, was, among other things, whether or not the respondent cannot be described as a member of the company because he had not fully paid up for his shares. So it was in the context of that the Supreme Court, speaking through Sophia Kufo, will make the point that if you're a subscriber to the regulations, now we call it the Constitution, that makes you a member of the company, as it were. We'll leave that here, and I would like you to go and read the full case, as it were. I would like us to now discuss the first section 24, and then we will look at the effects of regulations when registered. Yeah, so 24, take 24 for us. Yes, good to go ahead.
Section 24. Where a private company has delivered to the registrar its document intended to be the registered constitution, the rights, powers, duties, and obligations of the company, the board, each director, and each shareholder of the company shall have effect as provided in the second schedule, unless they are restricted, limited, or modified by the registered constitution.
Okay, so we've
Two,
already seen the second schedule. So we are just being reminded that if you are a private company limited by shares and you submit a registered constitution, it is deemed to be what we have over there, except that you can make changes as appropriate to you. The same thing applies to public company limited by shares in terms of section 24(2), and also company limited by guarantee in terms of section 24(3). We saw the fourth schedule, which provides the default constitution for company limited by guarantee. So that is what section 24(3) is telling us. But before we discuss the legal effects of the registered constitution, what about a company without a registered constitution? So let's look at section 25. And section 25 will actually be reminding us of what we'll be saying, that what we have in the schedules are the default. So if you don't register, no, if you don't register a constitution, what we have in the schedules are applicable to you. So please take 25(1) for us.
21, 25.1. Where a private company does not have a registered constitution, the rights, powers, duties, and obligations of the company, the board, each director, and each shareholder of the company shall be as provided in the second schedule and be deemed accordingly to be the constitution of that company, unless they are restricted, limited, or modified by a registered constitution of the company duly delivered after incorporation in accordance with this act.
Good. So what section 25 is seeking to do is not any different from 24. So 24 and 25 are simply saying that if a company would like to have its registered constitution, it's permitted, and it can make the necessary modifications to the standard constitution provided in the second schedule if it's a company limited, private company limited by shares, or in the third schedule if it's a public company limited by shares, or in the fourth schedule if it is a company limited by guarantee. On the other hand, if the company chooses not to have a registered constitution, then to all intent and purposes, the law consider that company as bound by the default constitution in the second schedule, third schedule, fourth schedule, as appropriate to the type of the company. That is all that section 24 and 25 is telling us. So that point is made. We move on to look at what is contained in the constitution, particularly registered constitution. So let's look at section 26.
Section 26. Please,
Yeah.
can I continue?
Yes.
Yeah,
Yes.
section 26.1. Where at yes, sir. Where at incorporation, a company opts to have a registered constitution, the registered constitution of that company shall state A, the name of the company with the last words of the name as required by subsection 1 of section 21. B, the names of the first directors of the company. And C, that the powers of the directors are limited in accordance with section 189, sorry.
Okay.
Please,
So
should I continue?
now we have discussed names of a company already in our last class, and what we discuss are applicable here when it comes to the constitution. Now, there's a the first directors, when you are going to register a company, you must have a minimum of two directors. And the name of the first directors are supposed to be included in the constitution. If the company chose to have a registered constitution as it were. Now that has given rise to some controversy as to whether those who become directors later on can ever get the constitution amended for their name to be included as first directors. So that came into play in the case of the Paul Wu treatment against Asari. And I'd like everyone to read it. Let me see if I put it here. Yeah. The case of the Paul Wood treatment. This is Asari. Two 2005, 2006, SCJLR 667. Yes, I'd like all of you to read it. Mm. Now, in the Paul Wood treatments against Asari, the court made the point that, quote, the regulations of a company incorporated in Ghana must have certain prescribed form and content, as well as recommended provisions, and may be changed in a certain prescribed manner. In the genesis of a company with shares incorporated under the code, there are three significant characteristics, and this is why I want us to pay attention. There are three significant characteristics that, in my view, may be likened to its genetic markers, the DNA. What are they? What are the three genetic markers, the three characteristics? One, these are the names of the first director of the company. So the name of the first directors of the company, the number of shares of no par value with which the company is registered, and the signature and names of the subscriber to the regulation, as well as the number of shares each is taking and the amount of consideration payable in cash, duly attested by at least one witness. These are pieces of information that must appear in order to be registrable. And the court was trying to make the point that these matters are such that you cannot reverse them. As to who the first directors of the company were, is a historical fact. You cannot, wish it away. It doesn't matter that the first directors are no longer in the company. And it doesn't matter that you are the one who came to actually develop the company for the company to assume a very high level of performance or achievement. You cannot get to a name written in the constitution of the company as a first director because that is historically not correct. And that's why she said that's like a part of the genetic markers or the DNA. Just how you cannot change your DNA. The same thing applies to certain historical facts about the company. Who the subscribers were. That is those who signed the document for the company to be incorporated. You cannot change it. Who the first directors were. Those who were the first directors of the company and then captured in the constitution of the company. You cannot change it. So that is the point the Paul Wood treatment against Asari is reminding us of. And that is consistent with section 26, 1, particularly D. Now let's move on to look at other aspects of matters which should be contained in the Constitution. Look at the 26.2. I'll read that 26.2. It disappeared. Okay. Yeah, so 26.2 is telling us that if you have a registered constitution or you later on choose to have one, you must state the nature. You may, no, not that you must. The word is may. It may state the nature of the business in that constitution, which the company is authorized to carry on. Or, if the company is not formed for the purpose of carrying on a business, the nature of the objects for which the company is incorporated. So this is very important. You see, unlike the past, if you look at the old position of the law, I have the old law with me. So if you look at section 16 of the repeal at 179, which was like the equivalent provision of the current section 26 we are discussing. So if you look at section 16, subsection 2 of the repealed at 179, it went as follows, quote, the regulations of a company shall state B, the nature of the business or businesses which the company is authorized to carry on, or if the company is not formed for the purpose of carrying on the business, the nature of the objects for which it is established. Now, I want us to pay attention to the textual comparison, the wording. If you look at the current rendition, section 26, subsection 2A, the provisions of, in fact, 992, provision says that it may state the nature of the business. And the word may, if we look at it in the Interpretation Act of 2009, it is permissive, meaning that it is not mandatory. So, under the current law, it is permissive. It is not mandatory for a company to state the nature of the business it seeks to do in its constitution, even if it chose to have a registered constitution. On the other hand, in the old law, that is the repealed at 179, particularly section 16, 2b thereof, it was not permissive, it was mandatory. So let's look at it. The regulation of a company shall state. So the modal verb used there is shall. So just as we have may here, over there it is shall. And again, in the interpretation that if you have shall is not permissive. Shall is mandatory. It's prescriptive. And you have no choice in the matter. So that is the difference. And that also explains why the so-called doctrine of ultra-vires, we'll come and discuss that maybe in our next class, where the so-called doctrine of ultra-vires has significantly been watered down under the current dispensation of the law, even if it's not completely abolished, as it were. Because ultra-vires, among other things, also go with the object clause. That is, what business is the company set up to do? If a particular transaction has been engaged in, is the transaction considered as having gone outside the scope of that which the company was registered to do? If the answer is yes, then you are likely to have it to be labeled as ultra-vires, and then the prescribed consequences will follow. But under the current dispensation, the emphasis on the registered constitution of the company, stating the nature of the business, the object of the business, is made even very liberal. It's very permissive. It's not mandatory. And that is why the doctrine of ultra vires we also see has also been watered down to a large extent under the current dispensation of the law. So let's look at the 2B. I think our reader has disappeared, so we need another person to be a standby. Okay, Nkansa would like to read for us. Okay. Yes, Nkansa, let's hear you. Edward.
26 2B, it shall deliver to the registrar I, the Constitution, and II, a special resolution of the company to indicate the intention to have the registered constitution.
Okay, so here we are talking about where a company was incorporated, and at the time that was incorporated, it didn't have a registered constitution, and later on, it opted to have a registered constitution. So that is where this provision kicks in. And in that case, you have to pass a special resolution. So a meeting will have to be held, and there should be a notice ahead of the meeting that they are going to adopt a registered constitution. And then when the meeting is held, 75% of those who attend the meeting and are eligible to attend must vote positively or affirmatively in support of the adoption of the registered constitution. Now, when that is done, that constitution and the special resolution will be submitted to the registrar for the requisite approval and registration. It were. 3.
And this is 3. In the case of a company having shares, the registered constitution shall also state the number of shares with which the company is to be registered.
Good. And DuPaul Wood treatment against Asari. Sophia Akufu JSC actually then was speaking for the Supreme Court, reminded us that the number of shares with which the company is registered is one of the genetic markers, the DNA of the company, the historical fact. And again, later on, when we are discussing the doctrine of capital maintenance, okay, the fact that the capital of the company should not be depleted, should be conserved, apart from legitimate exceptions, we will begin to appreciate why the Constitution says that the number of shares should be registered. You cannot issue shares more than the registered number of shares. If it becomes necessary for more shares to be issued, other than the total number of shares registered, you need to amend the constitution of the company to reflect that. Maybe there's a story from Kumasi, Ashanti region. I'm a shareholder of a bank called Odotobi Rural Bank and some other rural banks as well. Then there's this um, Jamaican who has been living in Ghana for a long time. It's called Steve Brightwit. So he probably sleep with the company's act. He reads the company's law and is a shareholder in a number of these companies. So if he sees that you are not going strictly according to the law, then he will engage you the next time you are aware. He will drag you to court for the court to hold you to the law. So he observed that a number of companies he was a shareholder in, they have been selling shares, issuing shares over and above the total number of shares with which they were registered. So he took his step and then did all the background checks and got the information and became certain that this company, according to its documentation at the Register of Companies, cannot issue more than this number of shares. But then it realized that it had actually issued more than that and decided to sue a lot of these companies. And eventually, they had to settle and they needed to do a lot of readjustment in order for their things to be in sync with the law, as it were. So these are very important matters. D.
4.
Yes, the D. You didn't read the D.
So we are at 26.4.
Oh, right. So 26 for good.
A registered constitution may contain any other lawful provision relating to the structure and administration of the company.
Good. Now I want us to pay attention to this. 24 says that it is permissible for the company, apart from these usual matters, which should be reflected in the constitution of the company, it is permissible for any other arrangement to be made as far as the structure and administration of the company is concerned, so long as those arrangements are not forbidden or prescribed by law. So we have that possibility there. And that is why when it comes to directors, for example, it is not, we have qualification of directors. And let's say that for the purposes of your company, you may want to include that to be a director of this company, you must also have these other qualifications. If it is not, for example, forbidden by the law, you can provide it, and that will be it. So, for example, if you look at somebody should jump to section 173, subsection 5, and read for us. Section 173, subsection 5, to illustrate the point I am making with respect to section 26, subsection 4. Please read for us, section 173, subsection 5. Use your hard copy. I'm not moving the screen. It means you don't have your law with you. No, you've delayed. You're not able to read. Okay, any person? Yes.
Sir. Section 173, my lord, the subsection
5.
5. The
173,
Constitution,
yeah.
173.5. The Constitution of a company may provide that classes of persons additional to those provided in subsection 1 are incompetent to the directors of the company.
Good. Now, if you read section 173.1, it gives lists of persons who are incompetent, who are disqualified from being appointed as directors of a company. Now, section 173, subsection 5 is telling us that it is permissible for the company by its constitution to add to a list of persons that it wants to disqualify from being appointed a director. So, for example, you're in a Presbyterian university, okay? The university can say that, and I'm sure they do, that if you are not a Presbyterian, for example, you cannot be made the vice chancellor, or you cannot be made the dean. I'm just using as an example. Or you have like the company, and it says that maybe if you don't have, let's say the company is about, maybe the oil and gas industry. And then there could be a requirement that if you don't have any qualification in petroleum law or petroleum management, you can't be member of the board of directors. So, section 1735 is saying that it's permissible. You can do that. And that is why section 26, 4 is also telling us that it is permissible for a registered constitution to contain any other lawful provisions relating to the structure and administration of what? Of the company. So let us keep that in mind. Okay, so let's move on to the subsection 5. Yes, subsection 5. Yes. Okay, I think somebody's hand is up. Regina. Yes, let's hear Regina. Regina, let's hear you. Regina, yes, you can release your mic. Your hand is up.
Malo, can I continue?
No, I think somebody's hand is up. I don't know if she has a question. Regina, let's hear you. You can release your mic. Okay, I think she's not conscious. Probably it's accident. All right.
So, say I can continue.
Yes. So continue.
26, subsection 5. In the case of a company that does not have a registered constitution, the company shall be deemed to have, as part of the constitution, under section 25, the matters with respect to the A, name of the company, B, names of its first directors, C, numbers of shares with which the company is registered, and D, number of shares subscribed by each shareholder on the incorporation of the company, and the consideration to be respectively paid for those shares as are respectively stated in the application for incorporation under section 13.
Good. So if you are a company which does not have a registered no constitution, one is already imposed on you. That is the default one, be it as a second schedule, third schedule, or the fourth schedule, according to the type of your company. But there are certain matters which are unique to you as a company. So the name of your company, your first directors, the number of shares with which the company is being registered, and the number of shares which the subscribers are actually taking and the money that they have paid. Now, you provide this in the forms which you fill when you apply for incorporation. That is what section 26.5 is telling us. And for that matter, those information you provide are considered as part of your constitution by the default one. Now we are going to discuss the legal effect or consequences of incorporation, which is very important, and every student should understand it properly. So we want to discuss section 29, effect of the company constitution.
My Lord, should I go on?
Yes.
Effect of company constitution 29, section 1. Subject to this act, the constitution has the effect of a contract under C. A. Between the company and each member or officer, and B. Between the members or officers themselves, by which they agree to observe and perform the functions contained in the Constitution as amended from time to time, insofar as they relate to the company, the members or officers.
Good. Now, let's explain before we move on. So, section 29.1 is telling us that the constitution of the company has the effect of a contract under seal. So, the question which arises is, what is a contract under seal? A contract under seal, also known as specialty contract or contract by deed, is a contract which is supposed to have certain formality, including writing and seal of the parties. For which reason, the law says that it is enforceable without the need of ascertaining whether consideration has been provided by anyone. So that is a contract under seal, used in contract distinction to parole contract or simple contract. Because I'm a teacher of the law of contract, I always remind you of contract whenever there's opportunity like this. So 29 is telling us that first and foremost, the constitution of a company, and mind you, it's not talking about registered constitution. It just said a constitution, meaning that whether you exercise the option to have a registered constitution or you chose not to have a registered constitution, in which case the default constitution we have under Schedule 2, second schedule, third schedule, fourth schedule are applicable to you according to the type of company that you are. The effects of the constitution we are talking about applies also to you. And if you had a registered constitution, the effect of the constitution we are talking about under 29 also applies to you. So that is a point that we should notice. Now, if you look at the old law, okay, if you look at the old law at 179, the equivalent provision of section 29 of the current Act 992 was what they call section 21. Section 21. And it is instructive to note that in the old law, the effect of the regulation, as it was then called, was limited to the registered constitution. So it said that subject to this, the regulation, when registered, have the effect of a contract under seal. But if you look at the current rendition, it says that subject to this act, the constitution has the effect of a contract under seal. And the chapeau, or the opening, or the preamble statement in this provision suggests that the lawmaker is now telling us that it doesn't matter whether you adopted your own constitution or you did not adopt your constitution, in which case you have the default constitution. The constitution has the following consequence or effect, that it is a contract under seal between the company and each member or officer. So the company is an entity on its own, as we know from Solomon and related line of authorities. between the company as an entity and each member. So there's a contract between you, a member, and then the company. In which case, the company has certain obligations towards you, and you also have certain obligations towards the company, and vice versa. It's also a contract between the company and officers. And at the same time, it is a contract between the members inter se, among themselves. A contract between the officers inter se, among themselves. In which case, they all agree to observe and perform the things which are set out in the Constitution as amended from time to time, so long as those provisions relate to the company, members, or officers. So let us keep that in mind. And again, the case of Adesheman Gardens Limited against Asibe, we are told that that case reinforce these same provisions, the effect of the Constitution. Now, this point that the constitution of the company has the effect of a contract under seal. That point was again underscored in the case of DuPaul Wood treatment against Asari. And also there's a very old common law position in the case of repealed against Hans. Repealed against Hans, and it is that place or that case that we actually get the court trying to develop the various contractual relationship which the constitution of a company brings into being. Let me write the case for you. Repealed against Hans. Maintain 62 All England Report, page 194. And in repealed against Hans, the Articles of Association of a Private Limited Company, which was incorporated in 1941, provided in one of its provisions, Article 11, that, quote, every member who intends to transfer shares shall inform the directors who will take the said shares equally between them at a fair value. So this was a provision in the Articles of Association, the Constitution. And if you want to transfer your shares, you must inform the directors. And these directors will now take the shares you want to transfer and share among themselves equally and pay the necessary price. Now, the qualification of directors was the holding of one share in the company. That was what the constitution of the company said. Now, some years later, about 6 years in 1955, the plaintiff, a member of the company, informed the directors for the time being of his intention to transfer his shares. But the directors refused to purchase the shares. Mind you, Article 11 has stated that you inform the directors and then you have to take the shares and share it equally among themselves and pay you so that they can go. Now here is the case. Someone wants to offload the shares, has informed the directors, but the directors have refused to buy the shares. And then he took the matter to court. And the court held that the directors were bound in contract to purchase the plaintiff shares at a fair value. And what were the reasons for saying that the directors were bound? According to the court, having regard to the Companies Act of 1948, which was the English company law at the time, particularly section 21 and article 11, the 21 is similar to some extent some of the things we are talking about in our own law. It constituted an enforceable contract between the directors as members of the company and the other members of the company on which plaintiff was entitled to rely without joining the company as a party. So please read the case of Refield and Hans, in which the court addresses the various contractual relationship which come up by reason of again, we have look at the Shemai Gardens, and we'll talk about how the court underscore the effects of the Constitution. Another case I would like you to look at is the case of Wood against Odessa Waterworks. Wood against Odessa Waterworks Company. It's a 1889 decision, 1889, 42 CHD, that is the Chancery Division, 3636. Now, in Wood against Odessa Waterworks Company, the company Waterworks was registered under the Companies Act of 1862. That's one of the very first company legislation, so to speak. Now, having applied the profits which had been earned to the construction of productive works, instead of paying the dividends to the shareholders, passed a resolution proposing to give to the shareholders debenture bonds bearing interest. So instead of paying shareholders their dividends, you say that we are going to create debentures for you. Debenture is, if you like, a permanent loan in the company, evidence in writing. So that's like the company owes you, and interest will be paid at certain intervals. That is what the directors sought to do instead of paying shareholders their dividends. The articles of association empower the directors, with the approval of the company, to declare dividend to be paid to the shareholders. Now, in this case, the claimant, a shareholder, opposed to this motion, opposed to what the directors were seeking to do. The directors were saying that instead of paying dividends, we are going to give shareholders debenture bonds bearing interest, equivalent to the amount of dividends that we have paid you. Now, this man wanted his money, so he wanted to call to challenge this move by the directors and sought to get an injunction. Now, the court had to decide whether the memorandum articles of association could constitute a contract, not just among the company and its shareholders, but also among the shareholders. And on that score, the court came to the decision that The articles of association constitute a contract between the shareholders, and that what was proposed to be done by the person of the resolution was upon the true construction of the articles, not in accordance with them. And for that matter, the court held that there must be an injunction to restrain the directors from acting on the resolution, and that was done. So please read these cases to augment your understanding of the provisions that we have been discussing. But one thing we should note is that in a sense, the doctrine of purity of contracts may apply to section 29.1, because if you look at the permutation of relationship under section 29.1, the contract which the Constitution brings into being is between the company on the one hand and each member, that is one, or between the company and the officers, that is two, or between the members inter se, among the members themselves, that is three, or between the directors themselves, that is four, or between the members and the officers, as it were, that is five. But it's not a contract between the company or any member and the third parties or outsiders. So the privilege of contract doctrine may apply that, as a general rule, if you are a stranger to a contract, you cannot enforce it. But then there is a caveat, and the caveat or the exception is in the section 29, section 29.2. So let's take section 29.2.
Section 29.2, where the Constitution empowers a person to appoint or remove a director or any other officer of the company. That power is enforceable by that person, although that person is not a member of the officer of the company, member or officer of the company.
Good. So this provision is answer to the question I raised earlier on as whether a third party, an external entity, someone who is not a member, who is not an officer of the company, whether he can enforce the contract which the constitution of the company brings into being between the company and the members, between the company and officers, among members inter se, among officers inter se, between members and officers. Now, in a particular scenario, in a limited situation, with respect to appointment of directors or removal of directors or officers, section 29.2 is telling us that where the constitution of the company has given the power to someone to appoint or remove a director or officer, that provision, that power is enforceable by that person, despite the fact that he or she may not be a member or officer of the company, so that he or she is not a party to this contract under seal, which the constitution of the company constitutes between the company and the member, between the company and officer, among members themselves, among officers themselves, between members and officers. The person may not belong to any of these network of contracts, but because the constitution of the company has named the person as having the power to make such appointment, such a provision will have effect regardless of the doctrine of privity of contract. And you may be wondering, if someone is an outsider, if someone is not a member of the company, under what circumstance may that person get the power to appoint directors? So that these things we're talking about, how does it become important? Well, you can appreciate it in a number of situations. For example, the company may be seeking a strategic investor, okay? Somebody to bring significant capital or money in order for the company to turn around to do some major projects for the good of the company. But the person may say that, okay, I'm not interested in becoming a shareholder. Neither am I interested in becoming a director myself. However, I want to have a say in who becomes a director of the company, who becomes the CEO of the company. I even want to appoint that person. That way, I am comfortable that my money or my investment is what? Is safe. So that is one of the instances in which an outsider may get the power to appoint or fire directors or officers. So where such arrangement is going to be made, the company may, for example, have to amend the constitution of the company and put in a provision explicitly conferring the power to do the appointment of the director or the officer on that person. And if that is what will let the person be happy, so as to actually give the money to the company, so be it. So let us keep that in mind. Let's look at the subsection 3.
Subsection 3. In an action by a member or an officer to enforce an obligation owed under the Constitution to that member or officer and any other member or officer, that member or officer shall, if any other member or officer is affected by the alleged breach of the obligation, sue in a representative capacity on behalf of that member or officer and all other members or officers who may be affected other than any who are defendants, and the provisions of section 205 shall apply.
Good. So when it comes to enforcement of the Constitution, mind you, the Constitution is now a contract. So if there is any breach, any of the parties may want to sue to enforce it, either a member or an officer, as the case may be. Or even, as we saw under section 29(2), an external person who has expressly been given the power to appoint or remove a director or officer may want to do that. Now, where that is the case, we have a practical challenge. What is that practical challenge or problem? There may be infraction of a provision of the Constitution. We have different members of the company, different officers, and many of them become cognizant, become aware of the fact that there has been a breach. Question is, should each of the members, officers, who have noted the breach by whoever, must each of them mount different action, different cases in court, seeking to remedy the same breach, the same violation. Now, if that were the case, you will be forced to do what we call consolidation. In civil procedure, there's something we call consolidation. So consolidation is where two or more cases having the same parties, the same subject matter are joined together so that the trial is done together instead of having separate trial. So that is consolidation. Now, we do not want that. So the lawmaker has stated that the company need not be saddled with multiplicity of suits, having different cases regarding the same factual scenario. So to avoid that, if you want to sue to remedy alleged breach of the constitution of the company, Section 29 3 is stipulating that you bring the suit in a representative capacity. You bring it in a representative capacity. And what is a representative action? A representative action is governed by Section 205. So please jump to Section 205 to tell us what a representative action is. Section 205. Are we together? 205. Anybody?
205.
Yes.
Representative action. Where under a section of this act, it is provided that if legal proceedings are instituted by a person, that person shall sue in a representative capacity on behalf of the person and any other member of a class A. That person may commence proceedings in that representative capacity without obtaining the consent and approval of any other member of the class represented and subject to paragraph B of this section. That person shall have the sole conduct of the action, and any other member of the class shall not be regarded as a party to the proceedings or liable for the cost of the proceedings. B, a member of the class represented may at any time before final judgment apply to the court for leave to be made a party to the proceedings, whether as co-plaintiff or otherwise, and the court may grant leave on the terms regarding the conduct of the action or otherwise that it considers fit. And if the leave is granted, the applicant shall become a party to the proceedings and liable accordingly to have an order for cost made against that applicant. C, a judgment given in the action shall bind and inure to the benefit of the members of the class represented, whether or not they have intervened in the proceedings in accordance with paragraph B of this section. D, the proceedings shall not be dismissed, settled, or compromised without the leave of the court, which may order that notice of the proposed dismissal, settlement, or compromise shall be given to the members of class represented and any other person. E, the proceedings under this section shall be supplemented by the provisions of section 200. And F, This section shall not affect the validity of an agreement between the members of the class represented relating to contributions towards the cost of the party or parties suing in a representative capacity.
Okay, good. Please read section 200, subsection 5.
200, subsection 5. 200, subsection 5. Where proceedings are instituted by a member, that member may either bring derivative action under section 201 or a representative action under section 205 on behalf of that member and all other members, except members who are defendants to the action, and shall join the company as a defendant, and to that representative action, the provision of section 349 shall apply.
6.
6. The court, on the application of a defendant, A, may stay proceedings by the member if satisfied that in all the circumstances, including the participation of that member in the transaction complained of and the circumstances in which that member became a member, it is inequitable that the member should be allowed to have the conduct of the action. B, may order the member to give security for payment of the cost of the defendants. And C, may direct that the member or any part of the action shall be heard in chambers.
Okay, good. Thank you. So, section 29.3 is telling us that we do not want the the company to be saddled with multiplicity of suit. Therefore, where there is a violation of the Constitution, it is an action which is maintainable by all members of the company or all officers who care to. So therefore, if you decide to sue, you are to do so in representative capacity. That is to say that you are not suing only in your own right. You are suing for and on behalf of all those who are similarly situated, who are similarly affected by what you are complaining of. And in that case, you have a choice. You may want to go solo, in which case you do everything by yourself. But if you do everything by yourself, the disadvantage is that if you lose and cost is awarded against you, you pay the cost all by yourself, including even getting your property sold, if that is what will enable the cost to be realized. Again, if you are successful, the benefits will not be enjoyed by you alone. It will inure to the benefit of all those within that class. So this is typically a class action, if you like, a class action, meaning that all those who are within the class, all those who are similarly affected, would take the outcome of the case you are going to do. And that is why it is prudent to try and get other members or officers who are similarly affected to join forces with you so that you share the burdens of the litigation. Because if you don't do that and there's a victory, the victory will not be enjoyed by you alone. It will be enjoyed by all members of the class. If there is a defeat, you bear the burden alone. So that is why it is prudent to get other members of the class involved. And another point to note is that where you take up a suit in representative capacity, particularly seeking to enforce the Constitution, you cannot just settle it among yourselves. The court will have to come in, and the court will have to ensure that all members of the class who are similarly aggrieved, even if they haven't come forward expressly to complain, they are notified of the pending suit and the proposal to have it settled before it can be settled. So let us keep that in mind. So let's look at section 294. 294. Where's our reader?
Yeah, I'm around 294. 294. Control of public invitations. A person shall not make an invitation to the public. A.
Oh, no. Sorry, I mean section 29, subsection 4.
29, subsection 4. Okay. 29, subsection 4. The registered constitution of a company shall be void to the extent that it contravenes or is inconsistent with this act.
5.
A registered constitution shall not be subject to a stamp duty.
Okay, good. So, first of all, much as the law permits the company to have a registered constitution, and then the registered constitution, you can make modifications of the default provision in schedule 2, 3, 4, and 5. The caveat is that it must not violate or contravene the Companies Act, whatever additions you are going to make. If it does, then automatically it's void to the extent of that inconsistency. And again, a registered constitution, you don't have to pay a stamp duty in respect of it. As a general rule, all contracts are required to be stamped. If a contract which has been reduced into writing does not have a stamp duty, you cannot enforce it. And we know the case of Lisori, in which the court have been quite strict that either a document is stamped and then it's admissible in evidence, or it is not stamped and it's not admissible. But when it comes to the company's constitution, despite the fact that it is a contract under seal, it is exempted from the obligation to pay a stamp duty. Now, I wanted us to finish, but it's not possible. So we have to do another session to discuss the alteration of constitution and also discuss what we call the shareholders agreement. So we have to draw the curtain down here and take questions and also allow those who have another class to get ready and go to campus.